Hi, my name is Jewel Salerno, and this is my final presentation for Business 343. I've chosen Case 6, Work Requirements for Holiday Pay. If you go to the next slide, we will do an overview of the case. In my case, I am an HR director for Saga Food Services, and we are going to look at the background of the case, the contract provisions of the union contract, and my reasoning why Mr. Arnett is not due to receive his holiday pay for Labor Day. If you go to the next slide, we are going to look at the case details. In this case, Mr. Arnett is a driver for Saga Food Services. He usually works Tuesdays through Fridays and is not normally scheduled to work on Monday. Labor Day holiday fell on a Monday this year, and normally, as it is practiced in the past, employees who are not scheduled to work on Monday would observe the holiday the following day, and in this case on Tuesday. So Mr. Arnett had Tuesday off. On Tuesday evening around 11 p.m., Mr. Arnett called his company and informed them that he would not be to work on the following day because he needed a personal day. Mr. Arnett did not receive permission to do this. However, the company does not refuse a personal day if the leave is requested at least an hour and a half before the employee's scheduled shift time. If you go to the next slide, the company later refused to pay Mr. Arnett for his holiday, claiming he did not fulfill the requirements of his collective bargaining agreement. The union then filed a grievance requesting that Mr. Arnett be paid because he did fulfill the requirements for holiday pay set forth in the bargaining agreement. If you go on to the next slide, we're going to look at the contract provisions. The contract provision states in Article 7 under holidays, Section 7.03, holiday pay allowances will be given subject to the following. The employee shall have worked his full scheduled workday immediately before and after the holiday, except for proven sickness or injury. The shift manager may offer to waive this rule in advance of the holiday and acceptance by an employee or employees based on seniority basis. In Article 23, Leave of Absence, Section 23.06, each present employee will be entitled to 4 days of personal leave per calendar year. The personal leave will be non-cumulative, and the personal days will be paid if not used. If you go to the next slide, we're going to look at my personal position of this case. My position on this case is that Mr. Arnett should not be entitled to his holiday pay because he did not uphold his agreement of Article 7, Section 7.03. Mr. Arnett did not work his full scheduled day immediately before or after the holiday, and he was not sick or injured, nor did he request approval from his manager ahead of time. If you go to the next slides, we're going to look at my research that supports my opinion. If Mr. Arnett is not happy with being paid for holiday time, he is entitled to file his grievance. A grievance is defined as a claim by an employee that he or she is adversely affected by a misrepresentation or misapplication of a written company policy or collective bargained agreement. And that's found in SHRM article, Society of Human Resources Management article. While I can understand Mr. Arnett's concern for this, he did not fully comply with the agreement set forth. So when a grievance is made, the supervisor and union representative may determine that no valid grievance exists. The grievance could be resolved if there was an error, or the grievance may not be resolved to the employee's satisfaction. If that's the case, then they'll move forward to the next steps. The next steps would be if Mr. Arnett and Saga Food Services does not reach an agreement with the grievance, or Mr. Arnett is still unhappy with the decision, the next steps would be arbitration or mediation. That's an option for them as well. These options tend to be more cost effective than going to court to reach a decision. Holiday pay and benefits is one type of dispute that is commonly resolved through the arbitration process. Holiday benefits usually are a very small portion of the collective bargaining agreement, but disputes of entitlement of holiday pay are quite significant to employees. If you go on to the next slide, according to the Fair Labor Standards Act, FLSA, employers are not required payment to employee for time not worked. So this includes both vacation and holidays. These types of benefits are only given as a benefit to employees and in order to keep the employer competitive in the job marketplace, but it's not a requirement. It also states in 10 answers to your HR questions that holiday pay is a benefit employers give to employees. It's not a requirement. The government does not regulate this. And then also in the article, Holiday Pay Practices, Do You Know Your Legal Requirements? They also concur that employees appreciate holiday pay as part of their benefits package, but it is not a requirement. In fact, there's no federal law that requires employees to get paid on holidays, and holidays are also considered typical working days. The plan of action that I would have as an HR manager of course, I would sympathize with Mr. Arnett, but he ultimately was the one who did not abide by the collective bargaining agreement. I would sit down with Mr. Arnett personally and explain the contract with him and outline the areas that he was misguided on. And ultimately, I would try to offer suggestions to possibly help recoup his pay from Labor Day and regain those missing wages. I would also send out a company-wide email to all employees, specifically emphasizing holiday pay so other employees who may have understood the contract could have clarification for future reference. If you go on to the next slide, you will find my references for this final presentation. Thank you.